Okay, hello everyone. Thank you so much for joining me on this Zoom meeting. Great to see that most of us are here. And today I have the pleasure of having two guest speakers, Felipe Estefan and Renato de Moraes. They are both in Brazil, actually, and they are experts in international arbitrage. So Renato de Moraes focuses on judicial and arbitration proceedings, representing clients on different sort of matters, both in the judiciary and in arbitration panels. He has a master's, an LLM from Cambridge University, and a doctorate in civil law from the University of São Paulo in Brazil. Felipe,
Hello, everyone.
sorry, yeah. And the other guest is Felipe. He has a solid experience in both consultancy and litigation in matters involving public infrastructure contracts, regulated markets, and dispute resolution in administrative, judicial, and arbitral proceedings. He has a master and doctorate in law from the Pontifícia Universidade Católica in São Paulo, Brazil, and a Master of Laws, LLM, from the Rotterdam University in the Netherlands. So I will let them speak and share a little bit of the amazing knowledge that they have in the topic.
Hi, everybody. Hi. It's a pleasure to me to be here today. Thank you, Ali, for the invite. I'm very glad to discuss this theme with you and also to interact from Brazil with you. And the topic I and Renato will discuss with you today is arbitration. And we are going to discuss a little bit about how arbitration is important for international development. And this is why, for purposes of having a structure, I will share with you a presentation, and so we can move on from it. Just 1 second, please. Do you all see the first slide?
Yes,
Yeah.
we do, Felipe.
All right.
Go ahead.
So let's start here. Yeah. So firstly, what is the meaning of arbitration? I think this is the first step for understanding what arbitration is. So arbitration is actually a system of private justice. It's not a court proceeding. So parties choose a third party, a third private party, and this third private party decides upon a conflict between the two contracting parties. So let's say, for instance, that Ali and Renato, they have a contract, a leasing contract, a purchase contract, and Ali says that Renato broke the contract. And on the other hand, Renato says that Ali broke the contract. They could, of course, use court. They could go to court and present the case before a public judge. But let's say they don't want to go to a court proceeding because they don't want to make the case public, or because they want an expert to decide on the matter. So they decide to go to arbitration. Can they do that? Yes, they can actually do this. They have this option. So arbitration is an option for resolution of conflicts. So let's think in this case that they choose me, for instance, to be the arbitrator based on my expertise on the matter or on my reputation, and bearing in mind that the arbitrator has to be impartial, neutral, independent. And let's say that in this case, they decide to nominate or indicate me as the arbitrator. In this case, they will have this arbitration agreement which is actually a contract where they choose that the jurisdiction will be uh, 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 private, and so I will have a mandate to decide on this conflict. All right. If they do so, they firstly will reject court proceeding, and so conflicts arising from this contract performed between them will be judged by me as the arbitrator. So they would not meet, they would not be in court for hearings or for presenting documents and evidence. They will be either in my office or we could go to a chamber like ICC, like LCIA. So depending on how the arbitration proceeding is built, they could either decide for a chamber or an ad hoc arbitration, which means that I myself would
Yeah.
build the whole proceeding.
And
So
let me add something here, Felipe. And if I and Ali, we, for instance, we have this arbitration agreement in our contract, and for any reason we go to court, I decide not to go to an arbitrator, I decide not to go to Felipe, but rather I choose to go to court, to a state court. The judge is going to dismiss the case immediately because he's going to say that I have chosen arbitration, and therefore my case should be adjourned by an arbitrator and not by a judge. Okay.
that's a very important point, because once they choose
Yes,
arbitrators
Abdullah.
to
This is
decide,
it's one way or the other. Exactly. You have to choose. It's arbitration. I'm sorry to interrupt, Felipe. Arbitration is based mostly on the consent of the parties. So if parties decide, if you have, of course, that there are matters that cannot go to arbitration. For instance, family matters, because there is like a public interest over the issue. So I cannot decide, for instance, alimonies, or I cannot decide like a child care before an arbitrator. But if I'm dealing with private matters, I am dealing with a contract, for instance, I am dealing with anything that involves exclusively the interest of private parties. Parties may decide to go to arbitration. And if they decide to go to an arbitration, the judiciary is going to reject this claim. The judiciary is not going even to analyze the claim. He's going to say, no, I'm going to dismiss this case summarily, and you have to go to arbitration because you have chosen arbitration. Is that clear? Good.
this is a very important topic, because one of the principles of arbitration is party autonomy. And then if parties decided that the conflicts of a contract will be decided by an arbitrator, then parties obliged themselves to use these mechanisms to solve their problems. All right, so this is very important for us to understand how arbitration is used. But let's say, for instance, that parties decide that mediation is also a mechanism that would be efficient to solve the problem. Is mediation a method that parties may use? The answer is yes. Mediation, not in this case, but if the contract is built in a way that mediation is considered to be efficient method, yes, they could use mediation instead of arbitration, or they can also use a clause which we call multi-tier clause, where parties firstly try to solve the issue via mediation, and in case mediation is not successful, then they may go to arbitration. But let's continue on this example I was giving to you, and so I think everything will be clear to you. So as I was telling you, all the proceeding all the hearings, all the contacts between the parties will be held not in public courts, but in office or in arbitration chamber. And there, Renato and Aline will be able to present documents, exhibits, and let's say in this example that I decide that Ali wins the case, and in this case, she will have, let's say, $5,000 arbitration award. With this award, Renato is obliged to pay her this amount. All right. In case Renato does not agree with the award and he rejects to pay it, Ali is able to go before courts and request enforcement of this award, which will probably be rendered by a judge, because arbitration in most jurisdiction is allowed, and because we already have an arbitration award, which makes res judicata. This is a legal
Yeah.
term to say
Let me
that.
try to go some steps behind here, Felipe, maybe because we are, they do not have expertise in law. There is a difference between win the case and get the money, let's say. So first you win the case, then you go and try to enforce the case. If the opposing party rejects to comply with the decision, you go to court and say, look, Ali is not complying with the judicial decision. Let's take her assets and let's sell these assets and then give the money. In a judicial proceeding, you do like that, you win the case, and then you start enforcing the case. All right. If I have an arbitration award, a decision rendered by an arbitrator, initially I don't have a place where to go in order to enforce it. So what do? I go to the judiciary. I say, look, judge, Mr. Stefan has decided the case in my favor. I have won the case, but the opposing party is refusing to accept the decision and is refusing to pay me the money she owes to me. So please, judge, enforce the arbitration award, and the court is going to enforce it. The legal system acknowledges an arbitration award, an arbitration decision, just like a judicial decision. Okay, this is something that must be clear. So the judiciary accepts, and even if, and then Felipe is going to move forward, and he's going to move in this direction. He's going to talk a little bit about how a judiciary from one country accepts or not an arbitration award from an arbitration panel or an arbitrator from a different country. Okay, go ahead, Felipe.
Yeah. So what we see in arbitration is that the arbitrator makes a binding award. So parties must respect it. And it's important also to point out that arbitration is different from mediation, for instance, which I mentioned before, and it's also different from conciliation. And I think it's important for us to understand a little bit more about the meaning of mediation and conciliation. And firstly, just to again mention the meaning of arbitration, then there we have this private system where the arbitrator renders this binding award, and then the parties must comply to this decision. And in mediation, differently, the mediator assists the party to reach a common outcome. All right, so he works as a facilitator of the debates and the discussion. There is no decision, there is no binding decision, and there is no award in mediation. In conciliation, we have the figure of the conciliator who convinces the party to agree upon an agreement. So the conciliator plays a more active role in comparison to mediation. But in conciliation, there is no rendering of award, there is no decision. All right, so these are the basic ADR, alternative dispute resolution. All right, so the most important one, I mean, the one that is mostly used in international field is arbitration. So this is why we are focusing on arbitration. In this first slide, we have a phrase of Gary B. Bourne, who is an arbitralist, a very famous one. And he says that arbitration is a process by which parties consensually, so it's a contract, all right, submit a dispute to a non-governmental decision maker, meaning a private party selected by and for the parties to render a binding decision resolving a dispute in accordance with neutral adjudicatory procedure affording each party an opportunity to present its case. So in this concept, we see that there is a contract. We see that the decision maker is a private party selected by the parties, and the arbitrator has a mandate to decide about the dispute between the parties, and that the arbitrator must be neutral, independent, and also impartial, giving the parties all the opportunities to present the case. All right, so there is a fair procedure, there is the respect of the due process of law in arbitration. All right, so this is the ideas we wanted to share with you about arbitration. So I will move forward to the next slide. Let me see if I can do this here. You don't see my web page, right?
No, we don't.
So let me try to do it differently. I think I prefer to skip this slide so we can move on with the presentation. If we have time in the end of the class, I can go back to this slide and we can do this activity. All right. So moving on, what is important also to understand are the reasons for international arbitration, or the reasons for arbitration in general. Why would a party, or why would contracting parties decide to use arbitration instead of going to courts, or instead of mediating the conflict, or conciliating the conflict? So the first issue I think it's important for us to point out is neutrality, right? So let's say that one party is from France, and the other one is from Mexico. Where should they arbitrate, considering that they want the jurisdiction to be neutral, to be impartial? They may choose to arbitrate their conflict, for instance, in Spain, in Miami, in Switzerland. So there is the flexibility for the parties to decide where they want the arbitration to take place. All right. And this is a possibility that is given to parties to in name of neutrality. So this is something very important for us to understand why parties should go to arbitration. Also, I think it's important for us to point out that international transactions and contracts are usually very complex, and so we should try to avoid jurisdictional disputes, and we should centralize all the disputes in just one forum. So if you choose arbitration, then you can avoid various jurisdictional disputes. We may choose the applicable law, and we may also not go for a national court, which may be not arbitration friendly or may not understand very much about the issue. So I think this is also a very good reason for us to decide to go to arbitration instead of using public courts. Also, I think I'm not going to talk about all of them, but I will just focus on the main ones. About the fourth topic, commercial competence and expertise. I think this is the most important one, especially in the infrastructure, in infrastructure transactions, because firstly, if we choose a panel of arbitrators and mixing legal and technical experiences, then we will have an arbitration award which is much more sophisticated than a decision made by a public court judge. So I think this topic, the expertise is something that is very important and very substantial in international arbitration international transactions that decide to use arbitration. Uh, Another topic that I would like to also discuss with you is about the costs of arbitration. Usually, the costs of arbitrations are higher than using public courts. But we also have, on the other hand, the flexibility of the procedure. And so the procedure is tailor-made by the parties. So it's rapider, it's speeder. And so the controversy may be dealt with and resolved earlier, so to speak. And so I think this is also an advantage of arbitration. So I think this is an important topic that I also would like to highlight to you. And also confidentiality, which is a topic usually emphasized by lecturers, because sometimes parties, companies don't want their numbers, their documents to be disclosed. And so you can opt for confidentiality in arbitrations. So confidentiality is also mentioned as an advantage of arbitration. All right. So I don't know if Renato wants to jump in. Please be my guest if you want to
No, I
comment
think for
anything
now
else.
that's okay. Go ahead, and I'll make some comments
All
in
right.
the
So
following slides.
good. So what's the difference between international commercial arbitration and domestic arbitration? There is the difference between them it's very clear. For having an international arbitration, you have to have an international element in the transaction. So either parties are from different nationalities, or the facts uh, are constructed in a way that uh, the interpretation of the transactions that it's international, or the legal matters are international. So if this is the case, then we have an international commercial arbitration. And the difference, the effect uh, that we can see about this difference is that if we have an international arbitration, then we will have to recognize the award before the court where we enforce the arbitration award. And this is important because if we are in a domestic arbitration, the case firstly takes place within one jurisdiction, and this is the jurisdiction where you will have to enforce the award. All right, so I think I just wanted to make this difference so you can understand where we are before a domestic
And
arbitration case or
just one comment
international.
here. In domestic arbitration, we decide to go to arbitration because the matter is very complex, uh, especially here in Brazil. Maybe the US is a little bit different. You have some complex dispute resolution courts. You have courts with expertise to deal with difficult matters. Here is a little bit different. So when we have here like a huge agreement, something usually involving companies or public entities, we decide to choose arbitration because arbitrators have expertise that judges do not have. Usually, judges they are more generalistic. They have a good overview of the law, but they are not expert in the specific matters of the law. Rather, arbitrators usually you choose as an arbitrator like a professor of a university or a very experienced lawyer to assist you in the matter. But in international arbitration, it's a little bit different because if you have an agreement involving parties in different countries, sometimes there is not trust in the courts of a specific country. Because, for instance, if my client is dealing with another client in the US or in France or in Germany, my client is not going to want to have potential controversies adjourned by a German judge. He does not know the German judge. He usually does not know the German law. He's going to have to hire German lawyers for the matter. So what parties usually do in this situation is to go to arbitration. And there are, for instance, ICC, there are chambers which are like bodies with expertise in dealing with international disputes. And then what you can do to improve the trust, the confidence of the parties in the matter. You usually choose arbitrators from different countries. Parties are also free to choose, for instance, the law that's going to apply to the matter, and this makes things easier. You can choose the language. So usually, if you go to international arbitration, you are going to litigate in English and not in your own language. So there are a lot of elements that you can use international arbitration to make your litigation more suitable to both parties.
Um, and just for giving examples of contracts where we may use arbitration, and according to our practice, we see arbitrations in contracts dealing with merger and acquisition, financial services, intellectual property, uh, purchases and sales, financial services also. So there is a great variety of transactions where arbitration is the selected forum to discuss conflicts. We are emphasizing the good side of arbitration, but I think we also have to discuss here the downside of arbitration and some points that I have here to discuss. Or for instance, that arbitrators, they cannot grant injunctions like freezing orders. So parties, if this is the case, they will have to turn to a public court to have these injunctions. So this is something that we consider as a negative side of arbitration. Also, as I mentioned, there is this possibility to have the confidentiality of the arbitration. And if we have this confidentiality, this may cause a lack of transparency of the arbitration, and then some actors may see this as something obscure or not complying with the rules which are applicable in a certain jurisdiction. So this is also another negative side of arbitration that I would like to discuss with you. Let's say the losing party does not comply with the award, then the winning party will have to enforce this before courts. So courts will have to help the party for purposes of receiving the amount awarded. And in this judicial proceeding, usually the confidentiality of documents is lost. So this is something that is very delicate also for merger and acquisition arbitrations, for instance. All right. And the topic that I also raised before, and I would like to again point out, is that arbitration are usually expensive because we have to pay for we have to pay arbitrators fees, we have to pay administrative fees, and there are a lot of products and documents that will be produced during the arbitral proceeding, and this is usually very expensive. So when you choose arbitration, you have to bear in mind that you will probably spend more money in this proceeding than you would in a court proceeding, in a public court proceeding. So also, this is also points that we should uh, 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 present to you so you can understand a little bit better about the downsides of arbitration. All right, so I will move on here to discuss a little bit about BITs, which are bilateral investment treaties, which are also transactions, but these transactions are entered into public parties, meaning states, and in biddings, uh, parties, they grant investors from one of the countries certain guarantees, such as fair and equitable treatment, protection from expropriation, free transfer of funds, and all these protections are made to avoid that an investor from another country which are who is putting money in another country uh, 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 may not continue to invest in this country. So what I mean here is that it's they try to protect the investor of one of the contracting parties who is making investments in the other country. All right. So usually they have in these bids international arbitration clauses, and arbitration in this case is seen as something that also protects the investor and also makes the capital investment possible. All right, so bids are also transactions where arbitration is usually a mechanism used. We we see these bids and we see arbitrations in many transactions, in many international transactions. And for the discussion today, we decided to use as an example the Chevron versus Ecuador case, which is a bid between the United States and Ecuador, where Chevron, an American company, invested in Ecuador. Uh, Chevron explores uh, oil and natural gas, and the company operated in Ecuador for a while. In this case, there were two proceedings, one in public courts and the other one in arbitration. The first one In the first one, the public courts ordered the company to pay a billionaire amount for environment damages caused by Chevron. And differently, in the arbitration, which was started by Chevron, the arbitral panel decided that Chevron was right and that the public court was corrupted, and then this public judgment should be annulled. So we have here uh, what we say, and we will discuss about it in the next slide, uh, a wicked problem, which is a difficult problem to solve. And this is very difficult, and this is a very complex cause because we have two sides of the story. We have two different proceedings in conflict. We have I will detail what happened in the next slide, but what we have in this case is violation of human rights. We have environmental damage. We have court corruption. And then my question to you is how to deal with this matter involving actors from the United States, from Ecuador, people who were harmed by these damages, and then this is more of a question than an answer, but how to deal with problems like this and how arbitration may play an important role to solve all these conflicts involving the damages. So to explain a little bit more about wicked problems, I would use as an example climate change, poverty, food insecurity, and also the pandemic may be classified as a wicked problem. And wicked problem, as these scholars say, they have this the wicked nature of these problems is not only caused by the lack of information, then I'm reading the transcription, or knowledge, or the technologically advanced nature of the issue, the presence of various actors with divergent or even conflicting interests and perceptions also play a role. So in this case of wicked problems, we we have often incomplete information or changing information or contradictory information, and we have to deal with them to solve the conflict, to solve the issue. And in terms of bids and in terms of arbitration, then my question for the reflection is how we deal with this problem that took place in Ecuador and how arbitrators or public courts may solve the issue. Uh, is there any other actor or public body that should play a role to solve this issue? Is arbitration enough to solve it? So there is a variety of questions that we can pose to understand a little bit more about this problem. So this is more of a provocation to you. Uh, just for us to understand more about the the side of the Equatorian people, just take a look at this video. Do 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 you is this sound okay? No?
It's not working for me, but I don't know if it's only me.
Try again, Felipe. I could not hear it. No, I do
No?
not hear anything now.
Mm,
I think you may have to share your sound as well, so
mm. This is something that I don't know how to do. Um,
if you want, I can share the video with the
yeah, I think if you
okay.
could share the
Okay,
video
yeah, I can share it.
after
Yeah.
our discuss here,
Okay.
it will be just great. The idea here is just to present their view, the native from Ecuador, presenting how uh, they are they were affected by the pollution and by the damages, environmental damages caused eventually by Chevron. And also, this is a discussion that has to do with Kovo doctrine, which is a doctrine developed by an Argentinian diplomat, and he defends that the domestic jurisdiction should prevail over the international arbitration jurisdiction. All right, so this is an issue because if we have bids and if we have arbitration as the jurisdiction decided by both countries, how can we say that domestic judgments or decisions would prevail over bids? So does
And
the system works or not? All right,
th-
so this
this
is,
idea violates the whole idea underlying investment treaty arbitration. If you're going to put a lot of money in another country, you want somebody impartial to decide potential controversies involving you and that country, that state. But if this dispute is going to be decided by a judge, by a court within that state, and you do not have trust on this specific state, there's no reason whatsoever why to continue with this investment. So if you're going to put, and I'm talking here not about million, but rather about billions of dollars here. If you're going to put billions of dollars in Argentina, for instance, and you know that the political situation in Argentina is something very specific, very peculiar. Of course, that you are not going to want that the Argentinian court is going to rule on the matter because probably this court is not going to be completely impartial. So what you choose an arbitration body. And but if the judiciary of this specific country does not respect the arbitration body, the whole system is collapsed, and there is no, and you're not going to have trust to put money in this state.
yeah, this is a very clever comment. And I also would suggest reflections about how the indigenous would feel um in this case, specifically because they were affected by the environmental damages and how they play a role in this whole scenario constructed by two states, which neither of them considered them in this relationship. So this is also something very delicate that I would suggest you to reflect. And also another reflection that, oops, my sound was on. Yeah, but also another topic that I would suggest reflection is about the corruption which was proven in this case in public courts. As you will see in the video, they were pretty much clear that the judges were corrupted by the lawyers defending Ecuador in this lawsuit, not Ecuador, but the indigenous in this lawsuit, in this public lawsuit. And also the representation was troubled because not everybody who appeared as claimants were actually claimants. So we have also to question whether whether courts in Ecuador were prepared to solve this conflict. All right, so this is also a question that involves the sovereignty of a country, and also involves how much the court of a country is prepared for international investments in the country, in industries of the country. So these are the reflections I would suggest from the topics we discussed in this presentation. Uh, Again, arbitration is something that is very important in the international environment because it gives safety for investors, and also there are many actors, lawyers, arbitrators, experts, who are all prepared to face wicked problems, but sometimes we see that some problems are not addressed as complex as they are. And so in studies we make about them, we should reflect on how we can improve the measures from the public point of view or from the private point of view. And so problems like problems that took place in Chevron versus Ecuador case, for instance, do not take place again. So I think I'm very satisfied with what I had to say to you. But Renato, would you like to add something more?
I think that the idea is already given. Maybe you guys should make any questions you have. We are talking here. This is an initial overview about something that is very complex. So if there is something that's not clear for you guys, or if you want to make some questions, I think Felipe and I we are going to be glad to answer them to you.
We have
I'm
few
sorry,
questions in the chat, so
Ah,
you can start with that.
yes.
sorry, yeah, I just saw them.
So I can read them to you. So the first one, if I understand correctly, an award decided by an arbitrator is judicially enforceable.
Yes,
That's
yes,
correct.
as long as it does not violate the public policy of the country and respects the due process of law. The scope of analysis from the public court point of view is very limited. So the only point that a judge will take a look when enforcing or not an arbitral award is whether this award respected the due process of law and the public policy of the country. So the answer is yes.
Let me try to make an example of what Philip is calling about foreign policy or public order. That's something that a
Guys,
concept
I'm
that
sorry,
we
I'm a
use.
lawyer. Sometimes I use legal terms.
No, this is something very difficult. Let me try to explain this thing to you. Let's suppose that we have an arbitration or even a judicial award from the US, and you want to enforce this in Brazil. You go to a Brazilian court, you say, look, I have this foreign award from an American court or an American arbitrator, and I want to enforce it in Brazil. If you fulfill some conditions, this is going to be enforceable. One of these conditions is that the award should not violate what we call here as public order. Public order are some concepts that are inherent to the society. And I'm going to give you another example of that. Let's suppose we are talking not arbitration anymore, we are talking about family law here. There is a judicial award from Saudi Arabia saying that the children are going to stay exclusively with the father because men are superior to women, and therefore women are not entitled to anything regarding children. This is probably not going to be accepted, ratified by a Brazilian court. Brazilian courts probably are going to say this violates Brazilian public law because under our constitution here, men and women are we equal before the law. Is that clear?
This is a very
It's something very very
good
exceptional.
explanation.
It's not something usual. It's very very exceptional.
It's pretty much clear to me at least. And just one
Is that
final
Abdullah?
remark.
Is that plausible? Okay, okay, good.
Yeah, good. Just one final remark about Abidullah's question. In Chevron versus Ecuador case, they tried to enforce the public judgment in Brazil, and our superior court did not accept it on the basis that it violated the public order because it was corrupted. Uh, at least there is evidence that it was corrupted. And also we have the information that in Canada, they were not able to enforce this public judgment. So I think this is also something that makes clear how much public order is important when you examine the enforcement of the award or not.
Okay, we have another question from Alina. Are domestic arbitrators less expensive than international arbitrators, considering cost of flights and other factors?
Hey,
Usually much
would
less.
you like to start? Well, I
Go ahead, Felipe, go ahead.
I wouldn't say that flights and lodging are the costs that will be the main costs in arbitration. So I don't know if
Unfortunately,
yeah.
it's extremely expensive.
Exactly. But you know what? In Brazil, there is right now a secretariat of ICC, and so we are able to pay all the amounts due for arbitrators and administrative fees in reais, which is our currency. And then there may be some discount, but I don't know if they are very relevant for investors or parties when deciding to go to arbitration. So I wouldn't say that domestic arbitration uh, based on costs of flights or lodging or other costs is cheaper than international arbitration. I think there are other factors
Uh,
at stake
if
here.
if you go to the chambers, like there are entities that have arbitration bodies, just like ICC and several other ones. If you go, each chamber they have a table with the costs. Costs are usually based on the value of the arbitration and not on where the arbitration is located, if whether it's domestic or international. But what usually happens is that international arbitration usually involves a lot of money. So that's why usually international arbitration is more expensive than a domestic one. But it's not impossible that a domestic arbitration is going to be more expensive than the international one for the same reason.
Okay, we have another question. What happens if arbitration fails to yield results when it's an international issue and neither country involved trusts the other judicial system?
Exactly. I think the Chevron case is a good example of not trusting the judicial system of another country. So in this example, we saw that they could not enforce the public judgment in other jurisdictions. And so I think the reputation of a jurisdiction and of a state is very important for arbitration, for international arbitration purposes. So what I mean here is that we have two important parameters. Again, public order and due process of law, which are parameters for us to examine whether the jurisdiction is compliant with the international order or not.
Yeah.
And so this is my comment about it.
But the consequences is that you litigate for like 2 or 3 years, you get an award favorable to your client, but if the opposing party, for instance, let's say you won an award in the US, but the opposing party has assets only in Brazil, and you need to bring this judgment to Brazil, you need to have it ratified by the Superior Court of Justice here, and the court rejects your request. What happens then is that your judicial award becomes only a piece of paper. It's completely worthless to you,
Yeah, but
unless you have another place
just
to go where you can find assets of the opposing party.
yeah, let me just go back a few steps here because I think my first comment is usually jurisdictions are arbitration friendly, and so um, there is this tendency to enforce international arbitral awards. All right, these two filters I mentioned before, they are important just to make sure the award does not disrespect the order of the legal order of the country where the award will be enforced. But let's say, for instance, that the losing party has assets in many jurisdictions, and then the lawyers of the winning party will have to start many enforcement proceedings all over the world to find assets. All right, but if firstly they don't find assets, then you are in bad sheets. But if you have assets and you have lawful arbitration award, then you will probably be successful. Was I clear? Yeah, was it clear? Yeah, all right.
And just in respect for your time, I just wanted to know if you have time for a couple more questions or not. I know you are.
I
very-
do, Ali.
Okay,
Feel free.
okay,
Fire them.
okay. So we have another question. What is the main incentive to use arbitration over public courts?
This is for you, Felipe.
What is the main what? I'm sorry, what
Purpose.
happened?
The main
purpose?
incentive to use arbitration over public courts?
Yeah, I would say I think firstly in Brazil for instance we have so many cases in our judiciary, and the same happens for instance in Italy, and I think all over the world. The judicial proceedings, they usually take so long to finish, and opposite to it, arbitration, they are usually the procedure is usually more flexible. It's tailor-made by the parties, as I mentioned, and then the decision, the award is usually quicker. You will have this award in a period of time which is much it's much less. And then I think this is the first advantage, and also the expertise. For instance, in intellectual property matters or infrastructure matters, where you need to have an expert to decide on the issue, on the conflict, I think arbitration is much better, you know. So I wouldn't go for arbitration, for instance, in a leasing contract conflict, because in many jurisdictions, judges and precedents, they are they are well constructed already. So you don't need to go for an expert to decide upon this kind of conflict. All right. So if you have a complex matter and you need an expert on the matter to decide on this topic, then you should turn to arbitration. And again, you can mix legal and technical expertise, because in arbitration, usually there are three arbitrators to decide, and then you can use a lawyer, an economist, an urbanist. You can decide. You can actually build your own tribunal. And so I think this is very magical about arbitration. And so these are the main reasons I would say you would use arbitration. You know, so you have to firstly think of the conflict, how special it is, and whether the judiciary is geared up to face it or not.
I totally agree with Felipe. Especially in domestic cases, arbitration is not for every case. It's only for specific, complex, and difficult matters, not for average matters. If you have an average matter, arbitration is going to be expensive and it's not going to be good for you.
The next question would be, what are the qualifications to become an arbitrator?
No,
No?
actually, yes, no, because actually anyone can be an arbitrator. If
Yeah.
it suffices that parties choose somebody as an arbitrator. So any of us here could be chosen to rule on a matter involving private parties. What happens in practice is that the arbitration, the chambers of commerce, they have arbitration bodies, and usually they have lists of arbitrators. And of course, to accept somebody in this specific list, they usually require that this person is qualified in law or in other fields of knowledge. For instance, in engineering, architecture, because sometimes you can have an arbitration panel composed of two lawyers who are going to make the proceedings, to decide procedure issues, decide how to apply the law. But it's going to be helpful, for instance, to have an engineer if you are talking about construction, for instance. So you usually need to have technical and academic qualifications to be accepted by the chambers.
Yeah, I'm completely with you. I think the credentials are important. Also, you have to be in compliance with your legal duties, and you also have to have an agenda for the arbitration, because the proceeding may have more than one hearing. You will have to study many documents, and then an agenda to have time for it is very important. And also you have to prove that you are impartial, that you are independent, and that you are neutral, and that you are not involved with any of the parties. And so you have to be compliant with a few requisites to be an arbitrator. And as Renato said, chambers usually have a list of their arbitrators, but this does not stop parties for indicating or nominating other people from the list. in this case, this person will have to prove to the chamber that she or he is compliant with the independence and impartiality requirements. How do you
Abdullah has
prove
made
impartiality?
a very interesting question here,
Go
which
ahead.
is he has asked how you prove impartiality of an arbitrator. This is a very interesting question, and there are PhD theses about this issue. What happens is arbitrators, they have the duty to disclose. So in the beginning of the arbitration, arbitrators they fill a questionnaire about questions about potential relationships maintained with both parties, and they have not only the duty to fulfill this questionnaire, but also to disclose any potential matter that may affect their impartiality. So let me give you an example. Felipe and I have been recently accepted as arbitrators of a chamber of commerce here in São Paulo, and so we are in their list. If two parties they decide to choose either Felipe or me to be an arbitrator, they are going to ask me several questions about my background and about potential connections with the parties. If one of them, for instance, is a client of our firm, and I fail to disclose this in the arbitration, and this is discovered in the future, the award may be rendered null and void. This is something very, very serious and very, very relevant. So usually what arbitrators do is that they over disclose, because they are sometimes concerned that not to disclose something that may affect the award in the future. So sometimes the arbitrators say, look, I had a cup of coffee with the cousin of the sister, of the sister of the neighbor of the claimant, but there is nothing that affects my impartiality, because he is really concerned that in the future the award may be rendered null and void.
Okay, I know we have more questions, but I think we can wrap up, and maybe I can send the questions to you two, and you can elaborate on that just because of the time. And I just wanted to thank you both for this amazing lecture. I learned a lot as well, so I'm very happy that I was here, and thank you. And thank you for all the questions that the students asked as well.
It was a pleasure to meet you guys. Thank you for everything. It was very, very nice to talk a little bit with you.
Yeah, I had a great time. Thank you for the invitation, Ali. Thank you all for participating. I think we could discuss very interesting matters, and please reflect on the questions we put in the presentation, and also if you need any clarification or if you want to be in contact with us for questions, please just contact us. All right, thank you very much.
Thank you.
Bye bye, everyone.